So the big question tonight, where does it all go from here? Well, joining us now with analysis, the author of The Price of Principle, Harvard Law professor Alan Dershowitz, along with former U.S. Attorney Brett Tolman and Fox News legal analyst Gregg Jarret. Gentlemen, thank you for joining us. Brett, you're former U.S. Attorney. I want to start with you because I just can't get past the fact that a judge less than 2 months ago had to recuse themselves. We don't know exactly why, but he had to recuse himself from a Trump issue. And then less than 2 months later, he's making this ruling. I just don't get how that happens in today's legal system.
Jason, if the recusal came as a result of the political connection between this judge and Hillary Clinton, which it most likely was, then it really is outrageous that he would not again recuse himself when the main political adversary of Hillary Clinton, Obama, Biden, anyone on the left is former President Donald Trump. You would have thought that it would have applied also in this circumstance, especially in the criminal law when there's a lot more on the line.
And Craig, I love the piece you wrote on foxnews.com, but essentially, they were given a fishing license to go to town there on Donald Trump's residence. What's your read of what you read there in the affidavit?
Well, this is what I read. There are 20 pages of this out of a total of 30. So, you'll recall that Merrick Garland stood in front of cameras and microphones and said, "We will speak through our filings." Well, this is how he speaks. He muzzled his voice with black ink. He probably ran through 2 or 3 Sharpie pens to do all 20 pages of this. The first 8 pages we actually get to see, but that's simply a recitation by rote of legal statutory quotations and vague background information. But you do learn 2 things, 2 mistakes by the FBI Merrick Garland. First of all, they assume that all of these documents they want, or some of them at least, are classified without ever considering that Trump may have declassified them. Their second mistake is they automatically assume that these 3 statutes, criminal statutes, general statutes that they cite as authority that gives them probable cause to go into Trump's home is the controlling law. They never considered that it's not. The controlling laws of the Presidential Records Act. It is a specific statute that takes precedent over the general statutes, and it does give a former president a measure and a right of control and custody, access, and possession. But they never considered that. And neither, by the way, did the magistrate when he signed off on this.
Now, Professor Dershowitz, you've seen a lot of cases in your time. What do you make of this situation?
Well, I disagree with your 2 previous speakers. Reinhart did the right thing by signing the search warrant. Every single judge and magistrate in the United States would have found probable cause based on this affidavit. They may have narrowed the search somewhat, but there is absolutely no doubt there was probable cause. That's number 1. Number 2, the real problem is...
Professor, hold on a second. Yeah. Professor, hold on a second. I want to ask you a question there.
Sure, please.
The judge recused himself less than 2 months later on a case on Donald Trump. How does he turn around and goes and says, yeah, I can make a ruling on this?
Every judge would have made the same ruling, so it's no harm, no foul. The problem was not with Reinhart. It was with the Attorney General, who didn't follow his own guidelines. There should never have been a search warrant requested here. There was a subpoena issued, and what I read, and I read it all, of the unredacted material makes a strong case against a search warrant. There was no urgency. If they wanted a search warrant, if it was so urgent, they could have gotten it 5 months ago. And even when they got the search warrant, they waited 2 days. There was no justification for a search warrant. So if you want to talk about who's to blame here, it's not Reinhart. It's the Attorney General of the United States. He should never have sought a search warrant. The other important thing is there is enough evidence here to indict Trump, but Trump will not be indicted, in my view, because the evidence doesn't pass what I call the Nixon-Clinton standards. The Nixon standard is the case has to be so overwhelmingly strong that even Republicans support it. And the Clinton standard is Why is this case more serious than Clinton's case, where there wasn't a criminal prosecution? So I think the 3 points are: there was probable cause, they shouldn't have sought a warrant, there is enough for an indictment, but there will not be an indictment and should not be an indictment based on what we've seen up to now. Once it's unredacted, maybe we'll have to change our minds.
Brett, what's your reaction to what the professor
fair and
says?
Impartial judge would have taken a look at this thing and asked challenging questions and would have said, wait a minute, the controlling statute here is the Presidential Records Act. Why aren't you seeking an enforcement proceeding here to get the documents that you want? That's what a good judge would have done. I think a judge would have seen through this charade.
Yeah, name a judge.
Okay, let's let Brett Tolman. No, hold on. Let's let Brett respond to this. Hold on, Brett. What's your take?
If there's probable cause in this affidavit, it's in the redacted parts, because the unredacted parts do not have probable cause in them. It's not sufficient for based on what we know in order to justify the search warrant. I agree with the professor that a search warrant was not justified in this case, both because we don't have the probable cause necessary to issue it, but also because the very things that are outlined in the unredacted part explicitly indicate a back and forth dialogue. It reads more like a civil, a civil dispute. And let me tell you, Jason, if you have to take 38 pages to try to convince a judge that there's probable cause, you may have a problem with your case.
Look, probable cause is an extremely low standard. Warrants are given out like Christmas gifts. This judge did a much better job than most did. Most judges would not have issued the affidavit, even with redactions. This judge had no choice. I don't believe there's a judge in the country who would not have issued a search warrant. Yeah, some of them may have asked some hard questions, but the judge's job is different from the attorney general. The judge has to look at the evidence that's in the affidavit and make a legal decision. The attorney general has to make a discretionary decision, and he has to abide by Justice Department standards. So if you're going to point the finger at anybody here, point it at Garland, not at Reinhart. That's my view. I think they had enough to get probable cause, but they shouldn't have sought a warrant in the first place. And if they did seek a warrant, it should have been narrower. There's no justification for searching the closet of Mrs. Trump or even for going into the safe. I didn't see any probable cause for that. But general probable cause existed.
Greg.
Why didn't this judge take a look at the warrant itself and say, wait a minute, this is a general search warrant. That's a direct violation of the Fourth Amendment to the Constitution, which requires specificity, particularly described documents to be seized at particular locations. None of that is in this warrant. So a good judge would have seen through this sham and would have said, wait a minute, I'm not going to sign off on something like this. It's a violation of the target's constitutional rights.
Brett, what's your reaction to that?
This is not a normal case. This is not a standard case. It's one in which the president clearly can possess classified documents. The president also has the unfettered ability, the Supreme Court tells us in Navy v. Egan, that he can declassify documents. And so without the judge being informed properly of that, you don't have a basis in Judge Reinhart's position to understand whether or not you truly have a statute that applies in this circumstance. So the professor may be accurate, but we don't know yet. We don't know whether or not there was probable cause in the rest of that redacted portion.
Professor, hold on. I'm going to give you the last word here. But I want you to keep in mind that a president of the United States always, in perpetuity, has the highest classification that is possible. And to suggest that they're not in a secure situation when they're protected by the Secret Service, for goodness sake, is hardly a case to be made that they're out there floating out there in the public and pose a grave danger. And I do agree with you, the idea that they didn't act immediately, if there was such urgency, that why we're 19 months after Donald Trump left office, that now they're just dealing this, does not lend to their credibility right before we go into the midterms.
I agree with all that, but there was probable cause even without the classification issue. Remember, to get probable cause, all you have to show is that there is a probability that you can find evidence of some crime, and the crime specified in the warrant were not classified materials, but they included kinds of things that Hillary Clinton was charged with. Now, she was not subjected to a search warrant, thus the double standard. So I want to make a sharp distinction between what the judge did and should have done. I agree with you. He should have narrowed the search warrant. He should have asked some hard questions. But there was probable cause. Yeah. But there was not enough urgency for the Attorney General to violate the standards of the Justice Department, particularly against a future presidential candidate who is running against the president who appointed the Attorney General. In that situation, you have to be extra careful to make sure justice is not only done, but it's seen to be done, and this does not satisfy that standard.
And this now, gentlemen, you're getting to the heart of the nub. We got to move on. And I want to thank the three of you, but this gets right to it because you know what? When I was the chairman of the Oversight Committee and I issued subpoenas and Hillary Clinton took bleach bit and destroyed documents, when we issued subpoenas on the IRS for documents on political targeting and they destroyed documents, when we had these types of situations, guess what? The Department of Justice didn't go in there guns a-blazing with documents to go seize things. They handed out immunity agreements to those people. That's the rub. It's the unequal application of justice that makes this totally and fundamentally a targeting situation, and it's not right. And until Lady Justice acts the same with a Biden and a Clinton as it does with a Trump or anybody in between, we're going to continue to have a problem in this country. I got to move on. I went over time. Gregg, Brett, and Professor Dershowitz, I really do thank you for joining us tonight on Hannity.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.